From the opinion pages of the Wall Street Journal, this is Potomac Watch.
The last 7 days have been among the most consequential in Supreme Court history, certainly in recent Supreme Court history, with landmark decisions on religious liberty, Second Amendment, and abortion. We'll discuss what they tell us about the court's new majority, as well as the political reaction, which has been, how to put this nicely, volcanic. Welcome. I'm Paul Gigot here at Potomac Watch, a podcast with the Wall Street Journal with my colleagues Kim Strassel and Kyle Peterson. Folks, this may be the best week for the conservative legal movement since, well, maybe Marbury versus Madison. 2 victories on religious liberty. Carson v. Macon said a state, in this case the state of Maine, can't discriminate against religious schools if it also aids other private schools. Then today, Monday, a decision supporting a football coach who was fired because he wanted to pray at the 50-yard line after games. It's a victory for free religious expression. And a huge case last week, of course, expanding gun rights for owners, saying that a gun can be carried outside the home. It was a New York City case. The logic of that decision may be even more important than the case itself because it used a historical legal analysis that says that any regulation of guns has to be rooted in the history of such regulation in the United States. And that'll make it harder for states and cities to limit gun rights. And then, of course, the overturning of Roe v. Wade, the most important reversal of a court precedent since Brown v. Board of Education overturned Plessy v. Ferguson, which had enshrined segregation in public law. Well, with that as a prelude, Kim, what does this tell us about the current court and this new majority?
Well, a couple of things. By the way, I wasn't alive for Marbury versus Madison, 1803, but I'm still feeling pretty good.
I was, and I remember it well.
But, this in some ways, if you think about it, it's a triumph of a 40-year movement of the conservative push to try to put the Supreme Court back on the path where it is analyzing and making decisions on cases more from a textualist perspective. You have had groups like the Federalist Society, et cetera, really focused on this. And with Donald Trump, you had this opportunity to put 3 new justices on the court. And I think that's the second point is, wow, what a difference 1 extra justice makes. Because when you had this 5-4 conservative majority, what you saw was a real reluctance, I think, to take on some of these cases, in part because I think some of the more conservative justices were worried that with that narrow of a majority and a John Roberts, who is an incrementalist, that they might not get the decisions they hope. Now we have, with the addition of Amy Coney Barrett, this 6-3 court that has agreed to take on these huge cases, but then also to settle them very much in that textualist perspective. And this is the result you're getting. And finally, these answers to really important questions like what are the outer limits, as it were, or freedoms of the Second Amendment? This tendentious question for 50 years of Roe v. Wade. I think overall it's a great thing. We're going to get some better clarity in the whole judicial system as a result of this. But boy, is it something to see.
Yeah, it sure is. Now, Kyle, one, I think, reading that is hardly original from me, but it's being widely made, is that what we have seen here this term is that the centrality of Chief Justice Roberts has been greatly diminished. He's no longer the swing in the court. He most notably did not want to go all the way and repeal Roe v. Wade, as the 5-vote majority did. But what that shows is that he now has to persuade another conservative justice to come along with him and join the liberals, assuming he has the liberals, in order to prevail at the court and even to assign an opinion. And now I think the obituaries for his influence are a little extreme. He still carries great weight at the court. He played a big role in, obviously, the religious liberty case. He wrote the opinion in the Maine case. He provided an important vote in the gun bill. But he can no longer prevail by himself with the liberals, Kyle.
It does seem to change the incentives for him, because when he was the swing justice, he could decide the outcome of the case. And now he has a little bit of a different dynamic. The question for him now, if it looks like there are 5 conservative justices to rule one way, the question for him now is whether he would prefer to have a stronger 6-3 majority, which is a bigger majority, looks less divisive than these 5-4 cases. And then if he's in that majority, he gets to assign the opinion, which can be strategic to make it a little bit of a softer opinion, maybe, if you want to assign that to Justice Brett Kavanaugh, than if you would assign it to Clarence Thomas. And so it is fascinating to watch. It would be an interesting counterfactual to imagine what if you still had a 5-4 court, how the Chief Justice would rule and how some of these cases could have come out differently. But it is also interesting, I would say, that when Brett Kavanaugh joined the court, there was suggestions that he was too chiefy and that he would be easily swayed by Chief Justice John Roberts' efforts to pull the court toward the middle, to be more institutionalist. And in some cases, that may be true. I think if you look at the data, Chief Justice John Roberts and Justice Brett Kavanaugh vote together pretty often as a pair. And yet, on the other hand, the biggest case this term, overruling Roe v. Wade, Kavanaugh was not swayed by those arguments whatsoever. And he even wrote his own concurrence, basically agreeing with the majority's opinion in politer terms. So I agree that the Chief's opinion still matters and he still has influence and sway, but he no longer holds the Trump fifth vote the way that he did previously.
Kim, let's elaborate a little bit on your point about the vindication that this represents for the conservative legal movement. This goes back decades, the creation of the Federalist Society in law schools and community of lawyers created in the 1980s. Has become an intellectual catalyst for that movement and a forum for debating legal ideas that didn't exist really before, didn't exist in the law schools before, which are dominated, I think, by progressive professors. So that has played an enormous role. But remember, even 2 years ago, maybe even I think it was a year ago, Senator Josh Hawley of Missouri was complaining about a couple of decisions that didn't go the way he wanted, Bostock opinion on the civil rights law, including LGBTQ individuals, and had basically said that the conservative legal movement was a failure and that the appointments that had been made by Donald Trump were wrong, that they needed to change their way of making nominations. And he didn't really say how, except I think maybe directly asking some of these potential nominees how they'd vote on cases, which, of course, they were never going to answer. But this is the vindication for that movement.
I mean, there's no pleasing everybody, I guess. And Josh Hawley usually isn't happy unless he's complaining about something. But if you go back, Paul, this, as you said, the most important aspect of this was simply providing a counterpoint to an establishment that was overwhelmingly liberal in its view on the court and the reading of history and how you produce these opinions. And so suddenly you have this intellectual counterweight, and it's been phenomenally important, not just in molding entire generations of law students that have come up and given them a framework of how to think about things, raising new issues as time goes on. This is something I've had some fascinating discussions with. I remember Don McGahn, the former White House counsel, who was very influential in some of the picks that Donald Trump made to the court, talking about how that movement had changed its focuses or expanded them, I should say, over the years to, for instance, a long time. And often when this first got started, a lot of focus on cultural flashpoint legal issues like abortion. But over the years, the Federalist Society has come to focus a lot more, for instance, on the issues and worries and perils of the growing administrative state and the separation of powers, etc. So they've moved with the times. They've played a huge role in vetting a lot of, or simply providing some advice to political figures about the real stars that are out there. And they've been very organized in that regard. And you get a lot of complaints from the Democratic side about this group. But it is notable that if imitation is the sincerest form of flattery, there has also been a lot of discussion in the past decade in particular and efforts by Democrats to try to come up with some of their own organizations that look and function like the conservative legal movement because they've understood its power.
On the social political right, Kyle, you've had a lot of griping in recent years. Josh Hawley is one of the gripers, but there have been others, particularly some of the younger conservative writers who said, well, the conservative legal movement has failed because it's just too libertarian. They care about things like the separation of powers, they care about property rights, they care about the Chamber of Commerce agenda, but they don't care about social issues, and that we have not won any of those victories. Well, look at the last week. two big victories for the cultural right on religious liberty, one on abortion and one on gun rights. I mean, do they have anything left to complain about?
The other thing I find so strange about their argument is I don't really understand what they want to replace originalism or textualism with. What is the competition? And I think the argument that they have made underrates the importance of the legitimacy argument for originalism and textualism, which is what has made it so compelling to these generations of lawyers and judges and justices. And the basic argument is judges should be textualists. They should look at what the law says. They should be originalists. They should look at what the law meant to the people who passed it and what it meant to the public meaning of the text when the law was passed. And they should be chained to that meaning. And I don't understand what the competition argument on the right is, that we should stop interpreting the law the way that the law was meant to be written. And if so, then how is that any different from the living constitutionalism the critics of that for decades have said that, liberal jurists just kind of make it up as they go. And I haven't seen any acknowledgement among these critics on the right that what they want seems to be just make it up as we go, but make it up differently.
Well, that's right. I think their substitute is natural law or natural rights. Don't worry about the Constitution so much, but just worry about the natural law principle. But that's a discussion for another day. We're going to take a break, and when we come back, more on the Supreme Court and the political consequences of its recent decisions.
From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome back. I'm Paul Gigot with my colleagues Kim Strassel and Kyle Peterson. A couple more points about the long gestation period for the Supreme Court decisions of the last week. And I think, there's some luck involved too, Kim. Remember, President Bush wanted to appoint Harriet Miers to the court, who was then White House counsel. That was opposed by many conservatives, many Republicans, and of course Samuel Alito took her place. Alito has become a bulwark of originalism, not maybe as much as some of the younger justices, but certainly an important intellectual force on the court. Then you had Mitch McConnell in the last year of President Obama's term blocking Merrick Garland from getting a hearing on the court, saying the election would decide the issue. That election did decide the issue with Donald Trump's victory, and he ultimately was able to appoint 3 justices. And one thing I want to mention is don't forget the role played by Harry Reid and Chuck Schumer, 2 Democratic leaders in the Senate. In 2013, Harry Reid did away with filibuster for appellate court nominees. That set the stage for that same thing to happen and was a precedent for the decision to do so for Supreme Court nominees in Donald Trump's first term. And then Chuck Schumer, who was then the leader of the Democrats taking over from Harry Reid, blundered by trying to filibuster Neil Gorsuch. And that allowed Mitch McConnell, because of the support for Gorsuch, to be able to change the filibuster and confirm Gorsuch. And then that wasn't available to stop Brett Kavanaugh or Amy Coney Barrett.
Although they did do their best, and let's never forget the Kavanaugh confirmation in particular. And, for all Democrats spend a lot of time, they're griping, they're very angry to this day about the Merrick Garland situation. You recall a very important history here that even goes back a little farther to Bork and the use of the filibuster against him, disqualification, essentially. And that was really the beginning of Supreme Court nominations, particularly for the left, becoming very, very ugly affairs where you began to get fewer and fewer cross-party votes for different nominees that were sent up. The end of the filibuster, ultimately culminating again in this horrible Kavanaugh nomination fight, which was the ugliest I've ever seen and I hope never gets repeated. So there's a long history here. And as you said, luck too. And something that I would rush to tell conservatives or remind them that for all Democrats right now are suggesting the world is at an end and 6-3 majority is going to destroy everything that they hold dear, it was because of the unexpected death of Ruth Bader Ginsburg that there was an opening for Donald Trump to nominate Justice Barrett. And even a 6-3 majority is certainly not something that by any means will be there for any length of time. You just don't know because of the Justice justices' health and other things. And so it is good to see these justices act while they have the majority that they do. One other thing I would just like to point out, though, too, since we're making points about the Supreme Court, is that even as we're seeing some of these really momentous decisions, I do think it's important to note that in many other issues, I think Roberts still does hold a lot of sway. We tend to overlook a lot of the other cases that have come out this year, which are in fact unanimous Supreme Court decisions. You know, there was one about a Christian group that wanted to fly a flag in front of City Hall and had been denied. That was a 9-0 decision. Another 9-0 decision about elected bodies and whether or not they violated the First Amendment when they censored their members. We've had some 8-1 decisions, 7-2. We've also had some decisions, for instance, with regard to COVID in healthcare facilities and vaccinations, where Kavanaugh and Roberts joined with the 3 liberals on the court in a 5-4 decision. There's still a lot of intellectual diversity among these justices, too. And so while we're seeing a few of these cases that are really landmark, no one should think that this is an ideological court in any way.
Kyle, a couple of big cases still to be decided by the court this week, separation of powers case and administrative state case with the Environmental Protection Agency and the scope of its power could be very significant. And next term, they've taken a case on racial preferences, which could also be very, very significant. But let's talk about the political reaction to this last week. And we've got the Vice President of the United States commenting on Roe v. Wade, and then repeal, and then Alexandria Ocasio-Cortez.
This is the first time in the history of our nation that a constitutional right has been taken from the people of America. And what is that right? Some might ask. It's the right to privacy.
There must be consequences for such a deeply destabilizing action and hostile takeover of our democratic institutions. To allow that to stand is to allow it to happen. And what makes it particularly dangerous is that it sends a blaring signal to all future nominees that they can now lie to duly elected members of the United States Senate in order to secure Supreme Court confirmations and seats on the Supreme Court. This is what we're saying.
Do you think lying at a confirmation hearing is an impeachable offense?
I believe so.
Okay.
I believe so. I believe lying under oath is an impeachable offense.
Kyle, leave it to Chuck Todd not to challenge the assertion by Alexandria Ocasio-Cortez that the justices lied under oath, which I've looked at that record carefully, and I don't believe they came anywhere close to that. But apart from that, her comments do demonstrate that for a lot of Democrats is a DEFCON 1. And, if they could impeach him, they would.
Yeah, and the lie one is a particularly strange claim. I mean, here's a quote from Justice Gorsuch in his confirmation hearings. A good judge will consider it as precedent of the U.S. Supreme Court worthiest treatment of precedent like any other. There he's referring to Roe v. Wade. Justice Barrett was specifically asked whether she considered Roe v. Wade to be super precedent. And she said, I'm answering a lot of questions about Roe, which I think indicates that Roe doesn't fall into that category. And I understand that to people who are not steeped in these issues, you see something like that, Justice Gorsuch saying it's a precedent, you got to consider it a precedent like any other. That might seem to people who have not followed these issues that he's saying more than he really is saying there. But essentially, he's just refusing to take any actual stance on it because as a judge and a potential justice doesn't want to prejudge any of the issues that may come before him. And I think the same is true with justices on the other side of the aisle. So the incoming Justice Ketanji Brown Jackson, who is going to replace Stephen Breyer, she was asked about Heller, which is the Second Amendment case guaranteeing an individual right to firearms ownership. And she said, yes, Senator, all precedents of the Supreme Court have to be respected. She was asked, is it the same level as Roe v. Wade? She was asked about super precedent. She said, I'm not aware of any ranking or grading of precedents. All precedents of the Supreme Court are entitled to respect on an equal basis. And to me, Paul, those statements are almost precisely in parallel. You have justices on the right and left not taking positions on the issues, saying they're precedents. We'll look at them. We'll follow stare decisis and make a decision on them if a case comes before us. But I'm not going to signal to the Senate how I'm going to decide those issues.
Kim, what about the political reaction here by Democrats? I think that the impeachment isn't going to happen. The packing the court isn't going to happen. Joe Biden, to his credit, said he doesn't believe in adding justice to the court. The only way those would happen is if the Democrats held the White House, get 2 or 3 more seats in the Senate to break the filibuster, and then held the House as well. But what they're aiming for here, I think, is to, at least in this election cycle, is to drive Democratic turnout over the issues of abortion and guns to help save the House and Senate.
Right. This is their ultimate goal, is simply to make sure or try to elevate this to the top of the ballot and re-energize their people. And they feel as though they need to, as a result, show that they're fully engaged and willing to take any measure. You've actually seen some Democrats say that over the weekend, that the goal of talking about getting rid of the filibuster and packing the court is to, in particular, show some of their younger progressive activists that they are really leaning in and willing to take on this fight. It's going to be a tough haul for them. There were a number of stories this weekend that just pointed out that even, in the weeks leading up to this, after that draft opinion in which we didn't know for sure if this was really what the Supreme Court would rule, but it did seem pretty solid that it was headed in this direction. Nonetheless, the polls have overwhelmingly showed that the top focus for all Americans remain the economy, inflation, gas prices. That's also the case for independents, which is a very worrisome sign for Democrats. And also, the headwinds the president is facing with its approval rating. I mean, again, they don't have a lot to run on, so they're going to try this, but it does seem like a big lift.
Well, we are going to follow this politically. It's going to be a major issue between here and November, and probably as well leading into 2024. But the fascinating changes at the Supreme Court going to produce some fascinating changes in American law. So we will follow this closely. Thank you all for listening. Thanks to Kyle and Kim. And remember, you can catch us every day on your favorite podcast purveyor. And please write to us at pwpodcast@wsj.com. Thanks for listening.